Hello and a warm welcome to World This Week by latestlaws.com. This is a weekly program, so hit the bell icon to get notifications for new videos. My name is Sheetal Joon, Associate Editor, latestlaws.com, and I will be taking you through the significant orders and judgments passed by various courts in the country and some important international news from this week. Let's begin with Supreme Court this week. The Supreme Court has asked the centre to furnish details of issuance of notices in arrest done under the provisions of the Goods and Services Tax Act, saying it may interpret the law and lay down appropriate guidelines to avoid any harassment of citizens by depriving their liberty. A special bench of Justice Sanjeev Khanna and Justice M.M. Sundaresh and Justice Balram Trivedi, which is hearing a batch of 281 petitions challenging various provisions of the GST Act, Customs Act and the provisions of PMLA, voiced concern over the ambiguity in Section 69 of the GST Act that deals with the powers of arrest. The bench said it would interpret the law to strengthen the liberty if need to be, but not allow the citizens to be harassed. The Supreme Court has said that the benefit enjoyed by bank employees from loans free from interest or at concessional rate is a unique advantage enjoyed by them. This is in the nature of a perquisite and thus is liable to taxation under the Income Tax Act. A bench of Justice Sanjeev Khanna and Justice Dipankar Datta also noted that the fixation of SBI's rate of interest as the benchmark is neither an arbitrary nor unequal exercise of power, as the rulemaking authority has not treated unequal as equals. The court also held that the provisions are not iniquitous, draconian or harsh on the taxpayers. Rejecting a request for a ban on namesake candidates in elections, the Supreme Court has said that it cannot stop people from contesting polls if they are named after political leaders. Petitioner Sabu Stephen had moved a public interest litigation arguing that namesake candidates are propped up in high-profile seats to mislead voters. The petitioner stressed that the presence of such candidates has often led to heavyweight candidates losing by a slim margin. Namesake candidates are part of an age-old election trick in which candidates with names similar to that of a heavyweight are propped up by the rival parties. The idea is to confuse voters and get them to vote for the namesake, effectively harming the heavyweight. The Supreme Court has asked the police in states and union territories to ensure that no innocent individuals from backward communities are named in a history sheet. Initiating suo motu action, a bench of Justice Surya Kant and Justice K.V. Vishwanathan has said that there are studies available in the public domain that reveal a pattern of unfair, prejudicial and atrocious mindset. Police authorities in states and union territories should ensure that no mechanical entries in a history sheet are made of innocent individuals belonging to socially, economically or educationally disadvantaged backgrounds, along with backward communities, scheduled castes or scheduled tribes, the Apex Court said. The top court said that a history sheet is an internal public document and not publicly accessible report. Extra care and precaution should be observed by police officers while ensuring that the identity of a minor is not disclosed as provided by law in a history sheet, it said. Now let's have an overview of high courts. Saying that difficulty in collating information cannot be a ground to not disclose it under the RTI Act, the High Court of Delhi has directed the Delhi government to provide information pertaining to penalty imposed on school teachers for giving private tuitions. Justice Subramaniam Prasad dismissed a petition by the Delhi government against an order of the Central Information Commission (CIC) asking it to furnish the relevant data and asserted that a public authority cannot refuse to provide such information only because it is not available at one place and would take a long time to collate. The court said that the object of the Right to Information Act is to ensure transparency in the functioning of various departments, and it cannot be thwarted on the ground that the information being sought is voluminous. The Allahabad High Court, while dismissing an appeal seeking condemnation of delay, observed that the party which does not contact the council for 6 years cannot seek condemnation of delay based on the allegations that the council did not inform about the disposal of the case. The court stated that despite the fact that the application seeking condemnation was rejected by the revisional authority against which the writ petition was rejected by the court, the present appeal is also barred by limitation and no proper reason has been given for seeking condemnation of delay in filing the present appeal in the affidavit accompanying the application seeking condemnation of delay. The Patna High Court, while allowing a petition filed for quashing of an order passed by trial court, has held that in case under Section 504 of the IPC, provocation must be followed to intentionally insult, which may likely cause a person to break the public peace or to commit any other offence. The court observed that merely by using some untoward words as raised through complaint or using certain words that have abusive value, it cannot be said that a person received provocation intentionally out of insult, which may likely break the public peace. The single judge bench of the Jharkhand High Court has held that mere bald assertions of dowry demand will not suffice. There should be consistent evidence regarding the nature of demand, whether it was in cash or in kind. If there was the allegation of demand in cash, then what was the amount and who made the demand need to be stated. Further, such demand should have been made soon before the death. The need for consistent and cogent evidence in this regard is necessary for the reason that such deaths, legally termed as dowry death, occur usually within the confines of the matrimonial home, and that in absence of any direct evidence, statutory presumption is raised under section 113B of the Evidence Act. The single judge bench of the Andhra Pradesh High Court has held that mere apprehension that the accused would tamper with the prosecution evidence or intimidate the witness cannot be a ground to refuse bail unless the prosecution shows that the accused tried for such tampering or intimidation. The court noted that the objective of bail is to keep an accused person free until their guilt or innocence is established. It is established law that an accused cannot be denied bail based just on a fear that they may tamper with the prosecution's evidence or threaten witnesses unless the prosecution can demonstrate that the accused was actually tried for this kind of intimidation or tampering. Moving on to international news this week. Amazon.com Inc.'s Chief Executive Officer Andy Jassy made comment to the media that violated federal labor law, a U.S. National Labor Relations Board judge ruled. Comments Jassy made to reporters about the downsides of the unionization threatened employees that if they selected a union, they would become less empowered and would find it harder to get things done quickly. NLRB Administrative Law Judge Brian Gee wrote. The judge said that the Amazon should be forced to post a notice at its US facilities informing employees of their rights and committing not to threaten them. An appeals court in the Hong Kong has banned a popular song that was penned during the Chinese territory's pro-democracy protest of 2019. The ban on Glory to Hong Kong song, issued on Wednesday, came as the territory's authorities sought to remove the song from internet search result and content sharing platforms. The song incorporates defiant lyrics, including the key protest slogan, "Liberate Hong Kong, Revolution of Our Times." It was later mistakenly played as Hong Kong's anthem at international sporting events instead of China's March of the Volunteers in mix-ups that upset the city officials. The prosecutor's office at the International Criminal Court has appealed for an end to what it calls intimidation of its staff, saying such threats could constitute an offense against the administration of justice by the world's permanent war crime court. The Hague-based office of the ICC prosecutor, Karim Khan, said in a statement that all attempts to impede, intimidate, or improperly influence its officials must cease immediately. While the prosecutor's statement did not mention Israel, it was issued after Israel and US officials have warned of consequences against the ICC if it issues arrest warrants over Israel's war on Gaza. In the end, we have miscellaneous news. The Bombay High Court has issued direction to the state government asking it to equip infrastructure across the state prisons to facilitate e-mulaqat. A division bench of Chief Justice Devendra Kumar Upadhyay and Justice Arif S. Doctor, acting on a PIL file in this regard by the People's Union for Civil Liberties, has asked the states to implement the provisions contained in the government resolution dated 22nd March 2024 in all the prisons throughout the state of Maharashtra and shall also provide adequate infrastructure wherever required so that the government resolution dated 22nd March 2024 is implemented in its letter and spirit, and all the inmates in the prisons are given access to phone calls and e-mulaqat facilities. The Delhi High Court has stressed the importance of educating minors about the concept of virtual touch alongside traditional awareness of good touch and bad touch to better safeguard them against the evolving threats in the digital world. Justice Swarnakanta Sharma pointed out that merely teaching children about physical interactions may not be sufficient to protect them from the complexities of the virtual environment. Thank you for watching and have a nice day. This is a weekly program, and to get more information, please check the description box, and for weekly updates, like and subscribe to our channel.